All Progressive Congress in Rivers State has asked the Federal High Court in Abuja to restrain the Federation Account Allocation Committee, two others, and their agents from allocating or distributing any revenue from the Federation account to any of the local government areas, councils of Rivers State or within Rivers State until a valid local government council election has been conducted by the sixth defendant to democratically elect local government councils for Rivers State. Also sought to be restrained in that regard are the Accountant General of the Federation and the Minister of Finance for the Federal Government of Nigeria, who are listed as the first, second, and third in a fresh suit filed by the APC. The plaintiff in the suit marked FHC/ABJ/CV/1556/2024 is contending that in view of the recent decisions of the Supreme Court in suit number XC/CV/343/2024, Attorney General of the Federation versus Attorney General of Abuja State and others, and the Federal High Court suit number FHC/ABJ/CS/987/2024, funds could no longer be released to local government areas in Rivers State because no valid election has been conducted in the state. Listed as defendants in the suit are the Federation Account Allocation Committee, the Accountant General of the Federation, the Minister of Finance for the Federal Government of Nigeria, the Attorney General of the Federation, and the Attorney General of Rivers State and the Rivers State Independent Electoral Commission. The party also wants an order of injunction restraining the government of Rivers State and their servants, agents, hirelings, or proxies from distributing to, expending, or utilizing any public fund of Rivers State for the use of or the benefit of any of the local government council of Rivers State until the governor of Rivers State have been able to conduct valid election to democratically elect local government councils for Rivers State. The APC is equally praying for a declaration that the government of the Rivers State and the six defendants, having failed to ensure the existence of and to put in place a system of local government by democratically elected local government councils in Rivers State, by conducting a valid democratic election for local government councils in Rivers State, that is, for the election of chairmen and councillors for the local government councils of Rivers State, the first, second, third, and fourth defendants representing the government of the Federation are not entitled to and cannot allocate or distribute any revenue from the Federation account to any of the local government areas or councils of Rivers State until a valid election to democratically elect local government councils for Rivers State has been conducted by the government of Rivers State, represented by the fifth and sixth defendants. In a supporting affidavit deposed by Tony Okocha, the plaintiff said, by the recent decision of the Supreme Court suit number XC/CV/343/2024, the Apex Court firmly held and declared in respect of distribution of revenue from the Federation account, among others, that the amount distributed to and standing to the credit of local government councils in the Federation to only democratically elected local government councils. The APC said its suit challenged the process hurriedly being put into place by the Attorney General of Rivers State and RISEC for the purpose of holding local government council elections for Rivers State. It stated that in the said suit, the plaintiff premised their challenge of the process on a number of grounds, including the ground that the processes being put in place for the holding of the proposed election, which was fixed for the 5th day of October 2024, was in contravention of the provisions of items 11 and 12 of Part 2 of the second schedule of the Constitution of the Federal Republic of Nigeria, as well as applicable provisions of the Electoral Act 2022, in that requisite statutory notices were not given and provisions in respect of update of voters register were not complied with. He stated that the election held in contravention of the Constitution, the Electoral Act, and the subsisting judgment of a competent court of law is invalid. The party added that the local government councils of Rivers State have not been democratically elected to qualify them to receive allocations from or distribution of revenue from the Federation account. Judge, that was an extensive read, and there was need to bring out all these prayers, all these concerns, and whatever arguments that the Tony Okocha faction of the APC is, building their agitation and prayers upon. In view of these developments, what do you make of this entire story? Considering also that there is a recent Federal High Court judgment barring the CBN from paying state allocations to Rivers State. What do you make of this development in Rivers State at this point? Okay,
thank you very much for that. I must say that Nigeria is a democratic state. We are not in a state of nature where the rule of might prevails over the rule of law. So I must thank Chief Tony Okocha for not resorting to self-help and approaching the court to do the needful. Because I understand that before that purported election had, there were court orders that was not adhered to by the
court judgment.
Huh?
Court judgment.
Yeah, court judgment, not an order. That was not adhered to by the Rivers State Independent Electoral Commission and even the government. So they hurriedly went ahead to conduct, an election that was against the law. So I must thank Chief Tony Okocha for not resorting to self-help. He has gone to the court for the court to look into the matter to see if actually those who are claiming to be elected local government chairman today, if actually the election, passes through the law. So what he has done is something that every right-thinking person should applaud him. It is for the court. The judiciary is an arm of government, and their responsibility is to interpret the Constitution, the law. So let them look into the matter and see if actually those who are standing there today as local government elected officials are meant to receive allocation on behalf of the people, the local government. So I want to thank him. It's a very good one. We expect that the judiciary will do justice to the matter. Unfortunately for the government of the day in Rivers State, they have been known as people who have been flouting court orders, violating court judgment, not accepting court judgment, and going arbitrarily to what the court says. So I think this alone is an affront on not just the judiciary, but on the Constitution, the ground norm that all of us, believe that is the book that controls whatever we do, the actions that we take in this country. So I want the judiciary to look into the matter. If they found the Rivers State government to have contravened, the provisions of the law, the penalties are there. They should not just waste time to hit the hammer. Because if we don't do this, what that means is that tomorrow anybody can come and discard the judiciary as not being present and do whatever they like. So we must let the law is not emotional. Let nobody look at Chief Tony Okocha as being a cog in the wheel of progress. No, what he is doing is to ensure that the rule of law prevails over the rule of might. So for me, I thank him so much for taking the bull by the horn and asking the court to interpret what the position of the law is. So it's a good one.
Now, to a large extent, this move by Tony Okocha to pray the court to stop FAAC allocation, federal allocation from getting to the local government, might be met with a lot of, well, if I may rephrase, people might consider it as controversial, considering the outcry, in the outcry that followed the judgment of the Federal High Court barring Rivers State allocation. When you look at this, now let's look at the nitty-gritty, what Tony Okocha's concerns are. Now, his reason is to, according to him, that the conduct of the local government elections were null and void, an aberration of the law, and that the government of Rivers State did not follow through did not abide by the court judgment by Justice Peter Lefo of Federal High Court. Now, what were the court judgments? I've had reason to have some lawyers, on my show, and they had banters, and one was of the opinion that voters register is not needed. But one of the concerns, or one of the issues that Tony Okocha had, was that RISEC published the date without, first of all, updating the voter register. According to the Electoral Act, the voter register must be updated 90 days before the announcement of the date for elections. Now, that is on one hand. Now, on the second one, the judge barred INEC from releasing voter register to RISEC. But then the RISEC chairman said he has the voter register, though not legally given to by INEC, because INEC said that RISEC had applied for the voter register and they were still in the process of, legalizing all that, and the court judgment came, so they didn't release the voter register, which means what the INEC chairman had may be a voter register, but it's not a working document because it's not backed up.
It was not updated.
All right.
Probably the
now,
last one.
when you look at all these issues, isn't there a way around it? Because RISEC is saying that they are empowered by the law, local government law. There is a state law that empowers RISEC to conduct elections for local government. Is it not at the discretion of RISEC to conduct elections?
Yeah, it is at the discretion of RISEC to conduct the Rivers State local government election, subject to having the voter register. RISEC as a body, election management body, did not have their own register, voter register. I am over 18. I have participated in different circles of election in Rivers State and the national level. I have never seen any day that RISEC called for, registering eligible voters. They have always relied on the updated register from INEC as the law provides. So, since it is the law that RISEC would depend on INEC to, grant them updated voter register, they, like you said, they have applied. They were in the process before this court judgment came, meaning that INEC never released. So RISEC has even had gone against the law to have, from wherever, gotten what they said was the voter register. What that means is that they have disenfranchised a lot of people who have, moved from 17 to 18 and above, who are supposed to be eligible to, vote for that election. So obviously, RISEC did not comply with the provisions of the law. You are empowered to conduct election, know that, subject to you being presented with updated voter register. And only INEC, no other institution have that voter register, only INEC. So obviously the question is, where did they get the voter register that they used in conducting the election?
But when you talk about updated voter register, the argument would be that RISEC chairman says that he has the 2023 voter register.
That is not permissible.
Hold on, recall that that register was updated by INEC for the presidential and Guba elections. Okay. So wouldn't you say it's updated?
Which year are we in now?
We're in 2024.
You had 2023 voter register, and are you aware of how many persons who have crossed from 17 to 18 who are supposed to be eligible to vote? So you disenfranchise them simply because you do not want to follow the law. That's the reason for this. There were people who were even up to 18 as at the last time the voter register was updated, but they did not register. Today, they feel the need to register and participate in the electoral process. You disenfranchise them simply because you didn't want to follow the law. What they see, my dear, the challenge here is that the Rivers State government and its agencies and operators have refused to abide by the laws. What was the hurry for? It was just recently that Abuja State had their own local government election. What was the hurry for?